We are not battling with the decision of a Supreme Court, which has surreptitiously interfered in the business of Parliament.
Surreptitiously interfered with the business of Parliament?
Yes.
How?
You see, there's a Latin legal maxim which expresses the doctrine with the effect that what you cannot do directly, you can do indirectly. Quando allocate probitur ex director, probitur et par obligo. What you can do directly, you can do indirectly. The Supreme Court has no jurisdiction, whether imagined or real, to conduct or prescribe how the business of Parliament is to be conducted. The Supreme Court has no such jurisdiction. I mean, and it is sound, there's got sound jurisprudential basis that you cannot allow persons who are not elected by the people to determine how those who are elected by the people will conduct their business. So the only thing that regulates the conduct of Parliament is the Constitution and the standing orders. And the Constitution, to the effect that the Constitution says Parliament shall not pass retroactive laws, substantive limitation on the powers of Parliament. Parliament, before it considers any matter concerning chieftaincy, must be in consultation with the chieftaincy institution. Institutional limitation, procedural limitation. A bill to be introduced in Parliament must satisfy Article 106(2). It has to be accompanied by a memo setting out clearly the principles, the lacuna in the law, and the remedies to address that lacuna procedure. Apart from this, so when you want to hold Parliament to account in the Supreme Court, you can do it in terms of the substantive limitations on the powers of Parliament, procedural limitations on the powers of Parliament, and institutional limitations on the powers of Parliament. Apart from that, Parliament is the master of its own procedure. And the procedure in Parliament is regulated by the standing orders of Parliament. The Supreme Court is now saying, oh, the standing orders of Parliament, and particularly Standing Order 1093, which provides that a deputy speaker or a member presiding loses his original vote. The Supreme Court says it's unconstitutional. How can that be unconstitutional? That is the canon of interpretation that has been used to expose the manifest absurdity or the inconsistency in the Constitution. That the Standing Order 1093 violates when read together. The Constitution says the Deputy Speaker of Parliament has an original vote when presiding, while the standing orders of Parliament say that he loses that vote. So there is inconsistency clear on the face. What rules, what canons of interpretation did they employ? Did they purpose of article of order 1093 for the standing orders. Did they also avert their minds to precedents of the Supreme Court, and especially in before an Attorney General, that says that something to the effect that the procedure in Parliament or parliamentary business is the business of Parliament, and that the Supreme Court should not stray into that territory. That's why. So the jurisprudential basis for the invocation of the jurisdiction of the Supreme Court to strike down Order 1093 is what I'm questioning. Because remember, Simon, have you read Article 102 of the Constitution?
Yes, I have.
Is there some ambiguity in it?
No.
Have you read Article 104 of the Constitution?
Yes, I have.
Is there any ambiguity in it?
Well, the argument as made is that as in Article 102, there's clarity that says that the person other than the person presiding. But that is not expressly stated in Article 104.
Article 104. Article 104. Article 102 is that it's for the business of Parliament. When determining the business, the quorum for the business of Parliament. There are 1/3 members of Parliament. Apart from the person presiding. When you reckon the 1/3, you don't count the person presiding. The business of Parliament. So, when the Speaker is sitting in the chair, the members of Parliament are not 1/3. Can he count himself in? If counting himself in will bring him to 1/3, can he count himself in? Huh?
And
1/3 is about 92. No, let's let your listeners understand. Article 102. 1/3 is about 92 members of Parliament, of a 275 member Parliament. If the first deputy speaker is presiding for the business of Parliament, and the matter of quorum is raised, the members of Parliament in the House are 91. By Article 102, can the deputy speaker, first deputy speaker, or second deputy speaker add himself under Article 102 for the purposes of declaring quorum?
And they are saying that in the case of Article 102, it is clear that he cannot.
What I say is that business of, we are talking about quorum. We are talking about quorum. We are not talking about decision making. The only time quorum appears, unless otherwise stated elsewhere, is Article 102. Article 104 is taking the decision making. The decision making. You are going to take a decision on the matter. Then all the majority of the members, more than half of the members must be present on the floor. Or half of the members must be present on the floor. And a majority of the half taking the decision in that favor. It's not all decisions, ordinary decisions of the House. That's what they're saying.
So I think, is that not safe to assume that before you start the business, you ensure that you have 1/3, but when you get to voting, then you have to check for another quorum, and this time the quorum is half. And is that not the case where they can say that the first deputy speaker can jump in if the numbers are not?
First of all, immediately Parliament satisfies itself that it has a quorum to transact business, unless the matter of quorum is raised, there's the presumption of regularity. Okay? So one of the presumptions in law. So you can be in the house and only being 15 members sitting in the house and doing the business of the house. If no member of parliament raises a quorum, an issue of quorum, there is a presumption of regularity that quorum was satisfied at the time that the business was done. So you ask yourself, what was first deputy speaker? You see, what was he doing that day? What was he doing? Even though he said whatever presumption, but what was he doing? Secondly, we all know, in fact, the speakership of parliament is a hierarchy. It's a hierarchy. At the top of the speakership is the speaker. And both the constitution and the standing orders of parliament says that the speaker shall not be a member of parliament. The speaker shall be elected from outside the members of parliament. But we all know that the constitution and the standing orders of parliament makes it mandatory for first deputy speaker, second deputy speaker to be elected from amongst members of parliament. It's first deputy speaker, second deputy speaker cannot be elected from outside parliament. And if in the absence of the first deputy speaker and the second deputy speaker, parliamentary business ought to continue, parliament has the power and authority to elect a member present in parliament to preside for the business of the day to be conducted. And that person must be a member of parliament. So there is no doubt in my mind that the standing orders of parliament already contemplated that the first or the deputy speakers or any member presiding at any particular time must be members of parliament. And that attribute, a very important attribute of a member of parliament, is the right to vote. And that is what is described in the standing orders as the original vote. But the standing order 1093 says, when a deputy speaker takes the chair, or at any time a member is presiding, a member here means a member of parliament is presiding, he loses that original vote. Why do you think? What do you think is the intention? The intention is very manifest on the face of the provision, to insulate the chair against petty partisan politics and to ensure order, discipline, and fairness in steering the affairs of parliament. That's why they have insulated the chair. So no one doubts. We don't have any problem with the right of a deputy speaker, first deputy speaker, second deputy speaker to vote. Nobody has ever raised that issue. But he loses that right to vote when he takes the chair. It's so clear. And the purpose is so clear. So clear. Unless you are saying that those who drafted the standing orders were dumb. They didn't know what they were doing. Well, you can't come to that conclusion because they knew at all material times that they were drafting the standing orders. That the first and second deputy speakers will be members of parliament. continue. So, for the Supreme Court to say that Order 1093 is unconstitutional, that is the question. Which provision of the Constitution is inconsistent with the express provision of the standing orders? Or which provision of the standing orders is expressly inconsistent with the provision of the Constitution? Is there a provision in the Constitution which says that a deputy speaker shall maintain his original vote while presiding, while in the standing orders is the reverse, and so an inconsistency? The internal logic of the standing orders is so discernible that the Supreme Court ought to stay off disturbing the internal logic.
Well, I haven't said that, because you said they have created confusion. They have been clothed with the power to interpret constitutions where they see maybe a lack of clarity. You are saying that from reading everything, there's no issue as such. What will the speaker do in this?
There's no issue of vagueness. There's no issue of ambiguity. There's no issue of manifest absurdity. There's no issue. And even when you look at the canons of interpretation, where even the provisions of a law appear to be inconsistent with each other, the courts are not always in the haste to strike down those provisions. They try to reconcile those provisions. They try to find the reasons behind those provisions and try to reconcile them to make sense out of them. Unless reconciling them will lead to greater absurdity. No, it's a canon of interpretation. I mean, the drafters of the law must have intended something. That's the confusion I see. The first confusion is that the Supreme Court has come through the back door to interfere and determine the business of Parliament, how the business of Parliament is going to be conducted. The Supreme Court has no jurisdiction to determine how the business of Parliament ought to be conducted. It springs from the general position, jurisprudential thinking, that persons elected to occupy offices cannot be shown how to exercise their mandate by a group of people not elected. It springs from that jurisprudential position. Because they are elected, they represent the people. So they are the voices of the people. So the people themselves have said that this is how we want to conduct our business. How can somebody say the people cannot say that that's how they want to conduct their business? That's why most jurisdictions, and even in Ghana, the Supreme Court has at various times said that, well, let's not deal with the business of people. Let them solve their case. Let them determine. That's why you often hear the oft-quoted phrase that Parliament is a master of its own rules. And even where there are inconsistencies in the standing order, it doesn't say go to court. The standing order says that the speaker shall interpret this, and his interpretation is final. It doesn't say go to court. There's no way in the standing orders where it invites people to go to court to test the standing orders. They say the speaker.
And I was asking, what should be the response because I have listened to the speaker a couple of times, and he doesn't seem someone in a position to entertain this kind of what he has even described as interferences.
No, it's interference. It's manifest. I mean, you don't need somebody to look into the crystal ball and tell you that this is an interference. I mean, it's not just an interference. The government of the decision of the Supreme Court is to tell Parliament how to conduct its own affairs. And like the minority said, it appears to be a judicial support for the controversial e-levy. Because the age of Parliament is the same as the age of the Constitution. The first Parliament share the same age with the Constitution. For 30 years we have been practicing this constitutional democracy. And nobody has ever seen the inconsistency. 30 years. 30 years. Nobody has ever seen that a person presiding, being a deputy speaker, losing the right to vote, original vote, on matters before Parliament is unconstitutional. 30 years. See. This is why sometimes we think that Atubo was right when he revealed the outcome of his research on appointments to the Supreme Court and the decisions of the Supreme Court. Because you know, my good brother, uncle, friend, teacher, in his private life, you know what he was. My old lecturer, Nia Shikote, was the Chief Executive Officer of the Forestry Commission on the Kofo. Then Abigate was a partner at Sam Kochatenko. Yoni Kulende was a lawyer in Pepe Aduenko. You know where I'm going to?
Well, I have listened to Minority Leader. I've listened to the whip, the Minority Chief Whip, who are both your former colleagues. And the whip particularly says that they may have to go back to the Supreme Court to seek a review. There are those who point out to them that this is a unanimous decision. How do you overturn and get a unanimous decision?
Yeah, but the review of the jurisdiction of the Supreme Court, the review jurisdiction of the Supreme Court is not ousted by a unanimous decision, not so. The judges could all be wrong, not so. So there must be, except that there are precepts, there are conditions that you have to meet. So to invoke the Supreme Court has repeatedly said that the review jurisdiction is not an appeal jurisdiction. The fact that you have lost a case should not invoke EU motions that will let you go back to a review. There must be exceptional circumstances. So they must look for the exceptional circumstances and demonstrate the exceptionability of those circumstances.
But would that be the response that you is that the best response you think?
Well, I'm not saying that. I have also said that the Parliament should be interested in looking at the review of the decision, because the surreptitious interference in the business of Parliament must not be entertained by Parliament. But because the Article 130 of the Constitution, the Supreme Court has a jurisdiction to entertain matters, and matters of this nature, mostly in our jurisdiction and in other jurisdictions, what the Supreme Court has done over the years is to decline jurisdiction when they think that the situation can lead to conflict or might not advance the cause of justice, or might introduce some uncertainty in the development, promotion, and consolidation of our democracy. So, in such cases, For instance, I say again that, look, if I were sitting on the Supreme Court, and a matter of determining whether the budget of the 2022 budget had been passed or not, as people have said that that's a moot question and ought not to agitate our minds. Because we know that the budget was initially rejected by the NDC when the MPP side left Parliament. When they had opportunity at the next sitting day of Parliament, which was a Tuesday, the NDC boycotted Parliament. The MPP sat and reversed the decision of the minority which had been taken at the last sitting. Subsequently, both the majority and the minority sat to approve of the appropriation bill of the budget. It meant both the majority and the minority had taken the first step in the confusion as to whether the budget had been passed or rejected. And that first step was that they were considered estimates of the budget. Of which budget? Of the 2022 budget. So what importance will be served? What usefulness will be achieved if a declaration is made that that budget was rejected? The both parties have taken effort. And in fact, that budget is only being implemented. Not so. So I would have said, look, this is a good question. We do not agitate our minds with the whether or not the budget, because first of all, the budget is an operation. The parties who were antagonists in this matter had both taken first steps in the matter of the budget. And so what is our business determining whether the budget was approved or rejected? This is the budget that we are operating with. Even the judiciary have received votes under the budget for the purposes of administering justice in Ghana. So you see,